A very hearty good morning to all of you. Dear students, in the last class, we have started the last module of Hindu law, which is known as law of succession. And we have tried to analyze the definition of succession along with the various differences. Dear student, we have also tried to understand the need of the new law of succession and also discussed the impact of the codification of Hindu Succession Act. In the last class, the students, we have also discussed the major amendment which happened in the year 2005 and the new provisions which have been brought in, what ramifications they have brought on Hindu joint family. I discussed with you that the amendment took place due to the 17th report of Law Commission of India, which was headed by the chairmanship of Justice V.P. Jeevan Reddy, and the Law Commission brought certain suggestions which included the exclusions of daughters from participating in co-partnership property ownership merely by a reason of, we can say, of sex, and it was held unjust. So these are the few elements which we have discussed in the last class, and also we have discussed the dual mode of devolution of property, which used to take place under the Mitaksha School of Law. Now, after the coming of Section 6 of Clause 3, it has also been done away. So now there are certain cognates and grandchildren which have been added, which we will be seeing in our upcoming lectures. So to connect with where we left in the last class, we have tried to analyze the concept of what we can call it law of succession and its impact. So, dear students, in the very first case of Kesar Bai versus State of Maharashtra, I told you that the court laid down that now, in this case, Kesar Bai versus State of Maharashtra, which is the very first case visible on your screen, is of year 1981, and in this case, it was held that now we have one uniform law of succession for all Hindus, and all Hindu laws, we can say, and customary laws of succession stand abrogated. So, as I told you in the last class, this does not mean that there has been a total departure from the old classical law. The old framework has been retained. The basic classification of inheritance to the property of a Hindu female and Hindu male still exists. The Mitakshara bias of the preference of males over females and of agnates over cognates has been, we can call it, considerably withheld down. Okay, but as we have to go to remote hires, the rule of agnatic preference reasserts itself. This you have to note it, that is still when we try to work with the remote hires, the rule of agnatic preference is still there. Women's state and revisionary have been abolished, but who will inherit the women property is still depend upon the what we can call the sources or the source from which the women got the property. And therefore the concept of revisionary inheritance lurks in the background. Okay, so the doctrine of representation has been retained in respect of male heirs up to third degree of descent. It has been extended to cognate descendant also, but not fully. The per steps rule of succession is retained in respect of class 1 heirs. Okay, but in respect of other heirs, per capita rule is applied. So these are the basic things which I was trying to bring to you, the basic outline or the major amendment which happened. Coming to the topic of customary rules of succession. So it was held in the case of Hardan Singh versus Deputy Director. What happened in some tribes of the wife determination of shares still prevails. So it was held that such a custom is, this is the case of year 1992, Hardan Singh case. And in this case, it was held that such a custom is tribal and not territorial. So we have to understand that what is the impact of modification or amendment of the Hindu law of succession. And also we have to see that what its impact it has laid down on customary rules of succession. So the Hindu Succession Act preserves the dual mode of evolution of property under the Madakshara school. The joint family property is still devolved by survivorship, with this important exception that rule of succession will apply to a Madakshara co-partner if he dies leaving behind mother, widow, daughter, daughter's daughter, son's daughter, or son's daughter, son's widow, and daughter's son. So the female lineage, we can call it, has been brought in with an we can say under the Madakshara law, but there are certain things which are still in practice. So the Hindu Succession Act based its rule of the succession on the basic Madakshara principle of propinquity, which means that preference of the heirs on the basis of proximity of relationship. Okay, the Madakshara limited the effect. The only thing what happened, the Madakshara school limited the effect of the principles by twin rules of exclusion of females and of agnatic preference. So the rules are being there, but they have tried to bring in certain, we can say, exclusions. Okay, the rule of exclusions of female has done away. The only thing which happened now, earlier females were denied, but that have been brought in. While the rule of agnatic preference has been considerably modified so far, we can say that it concerns the nearer relationship or the nearer relations. The Dayabhaga principles of religious efficacy has been abrogated, and the modern Hindu law of succession is essentially what you can call a secular law, and religious or spiritual consideration are nowhere to be found. So a person has to, what we can say, a person so long as he is alive, he is free to deal with his property in any way he likes, which I told you in the last class also, if you are able to recall the last lecture. I hope so. The same thing here, but we are calling it that if a person so long he is alive, he is free to deal with the property in any way he likes. Okay, he's free and he can dispose the property by making a will in which he is free to lay down his own scheme of distribution of property after his death. And this is known as testamentary disposition. You able to get it? Okay. Whatever we are doing, a person is doing with wills. This is known as testamentary succession. Is it clear to you? I hope so. I will repeat it again. That whenever a person is alive, there is a discretion or a sort of a freedom which has been provided to a person on his property, and he may dispose of his property the way he likes by making a will, and he is free to lay down his scheme of any distribution of his property after his death. And this is known as testamentary disposition or testamentary succession. So if you dies if you dies without leaving a will, then it is the purpose of law of inheritance to determine the persons who will take his property. Okay, so now in a contemporary world, someone, if suppose the owner of property, an individual or of you can say holding a property. So under these particular terms, the law of succession is classified under two heads. One is the in-estate succession, which we have seen, or rather we have to discuss few things about this thing, and the other is the succession made by wills, which is known as testamentary succession. Okay, testamentary succession. Okay, so this is the succession which takes place by what we can call by the wills is known as the testamentary succession. Okay, so these are the two law of succession can be classified under two heads right now. Okay, and further when we discuss the what we can call the law of testamentary succession, it is concerned how best the effect could be given to the wishes of our testator, which means a person who is making the will, and what are the rules relating to making of a will and allied subsidiaries matters. Okay, the tester, the person who is making the will, enjoys full freedom of disposing of his property, or rather we can call it begetting of the property. Whereas the law of in-estate succession is concerned, the law of in-estate succession, we call it, is concerned with the matters such as who are the persons who are entitled to take property, say who are the heirs, what are the rules of preference among the various relations, and in what matter the property is to be distributed in a case a person has more than one heir. Okay, or what are the we can say disqualification of the heirs. So, and the allied and the subsidiary matters which are related with the term of state succession. There are a few elements which the court or the people have to consider while they work on what we can call in-state succession. Number one is to find out the persons entitled to take the property, that they should be the heirs. What are the rules of preference? Rules of preference, we can call it among the various relations, who will be preferred on whom. So the near relative, mother, son, wife, daughter, they are the preferred. And then comes your what you can call your brother, his children. Okay. So likewise. And in what matter the property is to be distributed in a case a person has more than one legal hire. There is one more than one, how the property will be distributed. So this is the ambit we can call of the in-state succession. To look after also, we can say the disqualification of heirs. What are the grounds on which a person can be, for example, disqualified? There are chances what happen in many of the cases when we come across the socio-economic conditions, we try to observe them. Many a times when people know that they are the person who will be getting entitled, or sometimes people are able to analyze that the dying person may dispose of his property by making a will. So there are many cases which have been reported across the country. Many chances people try to kill that person, they try to murder because of that particular murder, they can stop the will, or rather they can get the property quickly or fast. So these are the terms which we can call as that this disqualify the person of as a hire. So the law of in-state succession is more properly called the law of inheritance. In actual, the law of what we can say in-state succession, in a true sense, is the law of inheritance. The law of inheritance consists of rules, okay, which determine the mode of devolution of the property of the deceased on hire solely on the basis of their relationship to the deceased. And while law of testimonial succession deals with the rules relating to devolution of property on relation as well as the others. So dear student, this is the main distinction between the two terms, succession and inheritance. I hope you are able to understand it, that the law of estate succession is, to try to call it more properly, we can deem it that it is known as law of inheritance. So law of inheritance further can be classified or can be defined as which consist of rules to determine the mode of devolution of the property of the deceased on hires solely based on the relationship to the deceased. So one thing you have to understand, that through in-state succession, only the legal heirs are the people who get the benefit of the deceased property, to whom the property is transferred. In other words, because there is a list, and because of this particular testamentary succession, what happened? The law of testamentary succession deals with the rules relating to the devolution of property. The testamentary succession deals with the rules of devolution of property. The very first which we have seen, this one. This one. Are you able to get it? So what happened? The law of testamentary succession deals with the rules relating of devolution of property on relation as well as others. So there are, when you talk about testamentary succession, there are certain people who are not belonging to the family, who are outsiders. But what happened, because of testamentary succession, the property can be passed to an outsider through a will. Okay, there is an instance that there are people. I don't think that you may be remembering. In the year, say something 2010, 12, something. There was a big businessman, and she was a lady. So all the property she has passed or given to a chartered accountant. This happened in Kolkata. So from where I am able to recall it. So it is something which is done by the testamentary succession. Okay, because it is talking about the rules of devolution of property on relation as well as others. And this is the distinction between the two terms, succession and inheritance. Inheritance means that the person is having an inherent right because of his birth, of his family, of the laws of which have been discussed under the in-state succession. Okay, so the best word for in estate succession, if we say that, if you are not able to confuse this, what we can say, law of inheritance. This will be the most appropriate word, I suppose. Law of inherit, law of inheritance, Tante. Okay, so I hope that this tries to give you an understanding. Okay, now coming to another case of Pune versus Babana case. Okay, um, this is the case of year 1971, and in this case, it was held that apart from Section 30, which confers a person a power of disposing of his property by will or other testamentary disposition, his property, including the undivided interest in the Metakshna of Vasnari property. So, apart from Section 30, which you can say the power of disposing the property lies under will also. Through a will, a person is free to dispose his property, which includes the undivided interest in the Metakshna Kopasnari property. Okay, so the Hindu Succession Act 1956 deals with the in-estate succession. Coming back, okay, the we can say that the the Hindu Succession Act 1956 generally deals with, we can say, in-estate succession among Hindus, and we have to discuss the particular under the few heads which I have tried to bring to your knowledge of. Try to I will be working on it. Succession to a Hindu male and succession to a Hindu female, disqualification of heirs, and general rules of succession. Okay, these are the few points which we will be seeing under the in-estate succession. How a Hindu male will be succeeding property, how a Hindu female will be succeeding, what are the disqualification of a heirs, and what are the general rules. Okay, so in the case of Pune versus, what we will call it, in the case of Dado Raghunath, okay, this is the name of the case, and it was decided in the year 1979 by Bombay High Court. It said that the succession opens at the time of the death of a person. When a person dies, the succession opens, whose estate is in question and is governed by the law in force at the time. Okay, so it has to be governed by the law which is enforced at that particular period of time. You can't bring the classical examples of classical any code or what we can say precedent to just justify your claim. But the court will see the law which is enforced at that particular period of point of time. Okay, students, so this was regarding the customary rules of succession and the differences between the in-state succession and the law of inheritance and law of succession, which we have seen. Are you able to get it? Testamentary succession. So the next topic, small topic, you can say is that line of succession of pure settlement cannot be created by a Hindu. Okay. What happened now? A Hindu can dispose of his property via settlement or otherwise in any manner known to a Hindu law, but he cannot lay down the line of succession against the what we can call the law of Hindu law of inheritance. Okay, a Hindu is free to dispose of his property by any mode he wants, but he cannot lay down. He is not in a position that no, I will propound my law of inheritance. Oh, I am not happy. Generally, what happens, generally, this practice, what I have observed, I'm taking my family by, what you can say, maternal grandfather and all these people, or my mother's father's family, they are quite rich and all these things are there. But what I have observed that no doubt they have tried to provide everything in the sense that they have educated the mother, they have tried to spend on the marriages and other expenses are there. But what happened in Hindu law and Muslim law, or in I don't know about other countries, but what I have observed in India, especially in our country, people try to avoid giving the property to a female. They are having many, or we can call it sort of a notion that the property will get divided or whatever. So, what excuse has been brought in? There was my student before I joined HNL, we were doing LLB, and there we run two courses of LLB, DLLB and LLB. So there he was doing LLB, and he was an MBA, and he was called a mature guy at that particular point of time. And he used to discuss the law of successions and inheritance in details and transfer of property act. So one day he himself told me that there is an issue which is going on between his aunts and their ancestral property, which means his father's sisters. So I told them the law is very clear. You have to provide their shares. He told me that the aunts have brought a case in the court of law. That's why I'm doing law. I want to save my property. I was very much amazed. Why you are having such a bent of mind? So he explained to me, or he provided a reason that, but because we have already married them, we have spent on their marriage. Whenever they used to come, we have given what we can call gifts and so on, many things in marriage also. And then on their upbringing, education, all those things. So what is the need of inheritance? That has collapsed. So what I told him, the same thing applies to the male member also. The father has spent a lot of amount, huge amount on his education, on his upbringing. You're getting it. Or what do you call it? On his marriage. So what is the need of giving to a son also? So this is what which we are facing or observing in a society till date. And I'm just trying to give you few examples. We were very much, we can say that we were having the self-respect. So we never asked our maternal uncles and all those people. But what I see that people are having very, what we can call, they are having a very narrow bent of mind. So I believe in God, and I think that if anyone will do wrong, that will be noticed by the Almighty God. To be left the matter. But what I'm trying to explain is that this particular dilemma. That's why it is held that you are free as a Hindu, you are free to dispose of your property by any settlement, but cannot lay down the line of succession against the Hindu law of inheritance. Now, very rigidly, a person has to follow. He cannot bring his own chart, his own line of succession, or his own line of inheritance, or what we can call his own preference. No, he can't do that, or she can't do that. You're able to get it. And in the case of Tagore versus Tagore, the case which you are able to see on your screen, second last case, this has been held in the settled of what we can call series of decisions, beginning from the judicial committee decisions in Tagore versus Tagore. You able to get it? The same thing was pronounced in the judgment of Tagore versus Tagore. Okay, a Hindu can of course prevent the property from passing to his heirs and altering the course of succession by making a transfer into what includes a gift. When you will be studying transfer of property, you will get it. But right now, you just have to need a grasp because you are not passing your BLLB exam. you are passing your family law exam. When you will be getting your BLLB degree after a few years. So there are certain cases in which a property can be passed off when a person is alive through a gift, okay, or an executory gift or by a testimonial disposition in form of a will. He can also create a trust. Okay, few people can come and look after the property. A person can do that. He can make a will or trust. These are the modes of disposition, we can say, recognized by Hindu law. A Hindu can also enter into a family settlement, recognizing the rights of the parties to the settlement. Okay, the term of settlement deed, which whatever the case be, each party will have a share which will be valid, and it will be binding, and its validity is not being challenged. But again the same in the case of Brijendra Pratap Singh versus Premlata Singh. You will to get it. A Hindu cannot create an estate unknown to a Hindu law, or lay down in the deed of settlement of his property a line of succession against the principles of Hindu law of inheritance. Because if you do so, what will happen? It will result in legislating. He is trying to draft a law. You cannot draft a law when you are living in a country which is having its own constitution and its own sovereignty. Are you able to get it? You can't say that, oh, I'm not happy with certain provisions or the working of the court. Now we can what we can say, create our own courts and law. No one can do that. Not even the richest or the billionaires living in the territory of India. No, you may have heard about privatization of railways, privatization of airways, and whatnot, but not of courts, not of law. You can't do that. What will happen? That will create a chaos. What will be the need of legislations and other activities? Okay, so this is what I was willing to provide you what we can say, an outline of the important, essential, what we can say, the elements which are there and which checked, which needs to be, what we can say, discussed with you. I tried to bring it. Okay, so these are the things. Okay, now we have to move to our definition clause. There are certain terms which I want that you should know, and I want to discuss with you because they are important, and they are discussed under the Hindu Succession Act. Able to get it, so that you are able to understand in which context we are talking, we are discussing. It will help you to understand the things. So the very first is that which is defined in the section 3(1)(g), and intestate, which means that a person is deemed to die in state in respect of property of which he or she has not made a testimonial disposition, which means a will, capable of taking effect. So when a person dies without preparing or making a will, okay, when a person dies without making a will, he is called in state. A person is deemed to die in state in respect of property which he or she has not made a testimonial disposition capable of taking effect. It should also not only create a will, it should also in a position to take effect. Okay. So what we can say that it means that declaration or declaring the intention of the owner of property is required, dear students, as to how his property has to be distributed after his death. Are you able to get it? I hope so. Okay. So these are the few terms which I was thinking to bring to your notice. Okay. And we have discussed in length, so I don't think that it requires a more explanation. Section 3(g). So I would like to move to another section which is talking about the term hire. Under section 3F, it has been defined a person who is entitled to inherit property after the death of the estate is known as a hire. This is what we can say general definition. A person, we can break it for our own convenience. A person, okay. So person means both male, female, no issue. Who is, we will call, entitled to inherit after the death after the death of the estate is known as a hire. And here it has been defined that hire means any person, male or female, who is entitled to succeed the property of an estate under this act. This is means hire. It is not a very we can call a sort of a rocket science in which we won't understand it. You all know what is hire. Okay. So before I move to this term, I would like to draw your attention to the term hires. Okay. So hire is a term we have to understand. It says that any person who is entitled to inherit property after the death of the estate is known as a hire. So hire includes persons male and female, but the section is quite silent. So hire will include descendants. Descendants means the offspring of a person. Immediate offsprings or immediate descendants of a person who are his sons and daughters. The children of sons and daughters and their children and so on are also descendants. A person may have descendants through his sons or daughter up to any degree of descent. Number one, which you have to include in this term, if you are making notes, that the descendants, because the section is quite, we can say, it is not, it hasn't provided the detail. Okay, so we have to fill in the blanks. It also includes ascendants. Ascendants are the people, ancestors of a person, we can call, and they are known as the ascendants. This is the shortest form. Here you have to move upwards, so we will call ancestors. Immediate ascendants of a person, his father, mother, okay, the father and mother of his father or mother, grandfather, grandmother will be his ascendants. So any degree to what we can call their parents will include the hires. Then comes the word collaterals. Collaterals, what we can define, are descendant in parallel lines for a common ancestors or for a common ancestor or ancestors. For instance, we can call a brother is a collateral, sister is there, paternal uncle, paternal aunt, their children, maternal uncle, maternal aunt are their collaterals. Okay. So this was regarding the terms which we have seen. So today I have tried to bring in certain, with the help of case laws, customary rules of succession and line of succession I have discussed with you. So what I feel that for today, I would like to end here. And in the next class, I will be beginning from the term agnate, and further we will be seeing full blood, half blood, and so on. And then we will be moving to the different provision of the Hindu theme, what we can call of succession. So when I see or I try to check the law of succession, okay. So we have done with the in-state succession. Dear students, are you able to get it? Let me check the syllabus. Yes, I'm able to get the syllabus. So Hindu Succession Act, which we have seen, which we have to see. The very first topic was the in-state succession, which we have seen. Then we have to see succession to a Hindu male. As I told you that there are 4 topics under Hindu Succession Act which are covered under our syllabus, and I would be throwing light on them only. If you remember, just now I told you that the succession to a Hindu male, succession to a Hindu female, and then we will be moving to the what we can say general rules, in which we will be including disqualifications also, and the mode of succession of 2 or more hires also. So this is what I planned. and hires of Hindu mail and cognates, agnates, cognates we will be seeing tomorrow. So this way, I think it will take, we will be able to cover the portion. It is not so wide because things are plain and it is not a classical that you have to appreciate Privy Council and other thing and so and so on. They're all very much plain and straight. Okay. So dear students, this was for us today. I hope everything is great at your hand. Take your time and start preparing for what we can call for your midterms, for your internals. You are able to get it. Okay. So thank you for your patient listening.